Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammi. I am Executive Director and Vice President for Legal Studies here at the Foundation. For those of you not familiar with the Foundation, we are in our 46th year of free enterprise advocacy and education. We do our work in the courts at all levels, both federal and state, and we also are very active publishing, doing a blog, and as well as doing programs such as this. If you have an opportunity after the program, you want to learn more about us, check us out at WLF.org. Supreme Court's October term 2022 was full of impactful and memorable decisions. The thousands of businesses that contract with federal government, none were more impactful than U.S. ex rel Shoot versus SuperValu and U.S. ex rel Polansky versus Executive Health Resources. The first addressed when, under the False Claims Act, a contractor knowingly submits a false claim. The second dealt with the federal government's ability to dismiss a qui tam lawsuit. Our panel today convened last year, actually, to do a preview program on the Polansky case, and they were so insightful and right spot on their predictions that we decided to bring them all back with us today to talk about these two cases. So we're going to talk about the impact of these two decisions on False Claims Act litigation and regulatory compliance. We are recording the program, just to let you know, and if you have any questions during the program, please use the Q&A function located in the Zoom webinar toolbar to ask questions. Introduce our speakers, and then we'll start off our discussion. Jay Stevens is of counsel to Kirkland and Ellis, and most importantly to us, he's our chair of our Legal Policy Advisory Board. He served for nearly 13 years as Senior Vice President, General Counsel, and Corporate Secretary at Raytheon Company. He also has enjoyed a distinguished career in public service as Associate Attorney General of the United States, U.S. Attorney for the District of Columbia, and Deputy Counsel to the President of the United States, among other positions. Joining us today also is Josh Fougere, who's a partner in the Washington, D.C. office of Sidley Austin. He focuses his practice on appellate litigation, as well as critical motions and complex commercial litigation. He served as a law clerk for 2 U.S. Court of Appeals for the Federal Circuit judges and for U.S. District Court for the District of Massachusetts Judge Nathaniel Corton. Also, along with several Sidley Austin colleagues, Josh drafted a Washington Legal Foundation amicus brief in the Polansky case on a pro bono basis. Our third speaker is Steve Wood, who's a principal with Chuhak and Tecson in the firm's Chicago, Illinois office, where he co-leads the litigation practice group. Steve is active with a number of attorney organizations, including the Defense Research Institute and Lawyers for Civil Justice, and we're proud that he was a featured expert contributor on the False Claims Act for Washington Legal Foundation's WLF Legal Pulse, and he is also a former captain in the U.S. Marine Corps. Thank you all for joining us today. So we'll start off with the SuperValu case. Steve, the court granted cert to review 2 separate Seventh Circuit decisions, both of which held for the defendant, SuperValu being one and Safeway being the other. You give us a brief summary of the relevant facts, the questions presented, and the court's unanimous holding.
Absolutely. Thanks for the introduction, Glenn. It's a privilege to be with you and with the audience today. So the facts in the SuperValu case start with the defendants in the litigation, and there were 2 cases that were both decided by the Seventh Circuit before the Supreme Court granted cert. The first case involving SuperValu, and the second one, as you indicated, Glenn, involved Safeway. These were grocery store chains who maintained in-store pharmacies. They both, over a period of time, had implemented discounted prices for prescription drugs. One was a price matching program that matched a competitor's prices, but these were variously discounted pricing programs for prescription drugs for people who did not have insurance coverage. Now, under Medicaid and Medicare Part D, the government provides prescription drug coverage for qualified individuals, but CMS issued regulations that limit the amount of reimbursement to what is usual and customary. That's the key phrase here. Also, under the defendant's contracts with pharmacy benefit managers as well, they were not allowed to charge the government more than the usual and customary price that they charged to customers who were paying cash. Now, These discount programs began to create a legal problem for the defendants because they were offering discounts with such high frequency that the discounted prices started to look more like the usual and customary prices for cash customers. Nonetheless, the defendants, for at least some period of time, didn't report the discounted prices to the government. They continued to report what were basically the retail prices for these drugs. And in a number of instances, the retail prices were, let's say, multiples. There was evidence that they were multiples of the discounted price. There was also evidence in these cases in the way of internal emails that suggested that some of the defendants' employees recognized that given the frequency of the discounting, what they were reporting may not reasonably be considered the usual and customary price. And there was evidence that they wanted to keep the pharmacy benefit managers and the government from actually learning about the facts of the discounts. So this ended up being significant in the court's view. The district court held that the prices reported were not, the discounted prices were not usual and customary. I'm sorry, I stand corrected. The district court held in favor of the relator on the issue of falsity, but granted summary judgment to the defendants on the ground of scienter, that they did not act knowingly. I should point out that in 2016, the Seventh Circuit decided the Garvey versus Kmart case, which held that the discounted prices were in fact the usual and customary prices. So none of these defendants continued their discounted programs or at least continued reporting retail prices after that point in time. Now, in the SuperValu case, the first to be taken up by the Seventh Circuit, the court framed the issue as whether the Supreme Court's interpretation of the Fair Credit Reporting Act scienter provision in Safeco Insurance Company versus Burr, whether that applied with equal force to the False Claims Act scienter provision. All right. And basically the Seventh Circuit held that it did and indicated that they were siding with 4 other circuits who had held similarly. It's worth mentioning that Safeco interpreted the term willfully in the Fair Credit Reporting Act that a defendant could not be deemed a knowing or reckless violator of a legal obligation if the obligation allowed for more than one reasonable interpretation, and the defendant acted consistent with one such interpretation. And of course, that there was no authoritative guidance, meaning something from a government source that was sufficiently specific to the contrary. The Seventh Circuit basically read Safeco to dictate a 2-step inquiry for ascertaining whether a defendant acted recklessly or knowingly. And at step 1, the court would look at whether the defendant's acts were consistent with an objectively reasonable interpretation of the law that had not been ruled out by definitive legal authority or guidance. And this step, the Seventh Circuit held, applied regardless of whether the defendant actually believed such an interpretation at the time of its claims. Only if the defendant's acts were not consistent with an objectively reasonable interpretation would the court proceed to this step 2 to consider subjective evidence. Right. Now, the question presented to the Supreme Court was whether the objective knowledge standard articulated in Safeco applied in the context of the False Claims Act's scienter requirement, where a claim's purported falsity turns on an ambiguous legal obligation, or as phrased by Justice Thomas, the author of the court's opinion, the question presented is whether respondents could have the scienter required by the False Claims Act if they correctly understood that standard and thought their claims were inaccurate. The holding, which was unanimous in this case, was that facial ambiguity alone is not sufficient to prevent a finding that false claims were submitted knowingly. The False Claims Act scienter element refers to a respondent's knowledge and subjective beliefs, not to what an objectively reasonable person may have known or believed.
The term knowingly reflects the common law definition, meaning actual knowledge, deliberate ignorance, or recklessness. Which of those did the court say that SuperValu and Safeway possessed, Steve, when they submitted their claims?
Well, this was really a recklessness case, a reckless disregard case, an awareness of a risk that they may not be acting or reporting the correct usual and customary price, but nonetheless, they continue to report their retail price, the much higher retail price anyway. So this really was a reckless disregard case.
the court rejected the company's points that because the rule at issue was ambiguous, there was no way of knowing their understanding of it was wrong. Josh, what was Justice Thomas's reasoning on that point?
Yeah, and this picks up on what Stephen was just saying. The issue there from the defendant's perspective was basically, can you know something that is unknowable? Ambiguity without authoritative guidance from a court or a government agency with the authority to give it means that the answer could be, there could be multiple different answers. And can you actually know one answer or the other until you have some sort of definitive resolution from an authority that could give it? And what the opinion seems to say is that facial ambiguity all by itself does not preclude a finding of scienter, and does not all by itself mean that a defendant cannot know the answer was wrong. Even that conclusion was full of caveats. According to the relators, the defendants had received notice that their interpretation of usual and customary was wrong and tried to hide their prices. So Justice Thomas says, if that is true, then perhaps the defendants knew what the term meant, or there was an unjustifiable risk that their view was wrong. And if that's true, they quote unquote may have known the claims were false. But baked into that reasoning, and picking up on what Stephen was just saying, seems to be some idea of respondents' ability to learn or become aware of the correct meaning of an ambiguous legal obligation. The court offered a hypothetical about a driver who's told what speeds a police officer thinks are reasonable on a particular stretch of roads, but then exceeds those speeds, suggesting that a driver can't justifiably complain about an ambiguous standard if it later exceeds the speeds it gets caught. But what the court didn't address was the driver who follows the guidance given or attempts to follow ambiguous guidance and is later told the guidance given was wrong or the speeds traveled in reliance on that guidance were excessive. So more on this to come, but the court's refusal to address these points is it's pretty stark in light of the fact that the companies in this particular case had pointed to significant evidence that the government agencies and the courts interpreted the law just as they did during the periods in question, at least until 2016, when Stephen says there was a Seventh Circuit decision saying, in fact, this is what usual and customary means.
So Jay, as someone who's been on both sides of the V involving the False Claims Act for a good part of your career, do you think that the court had an overly rosy view of the rules that govern government contractors and their ability to discover the correct interpretation?
Thank you, Glenn. The short answer is perhaps yes. And I would say, particularly from the perspective of a practitioner and perhaps from the perspective of the Department of Justice as the primary enforcement agency for the False Claims Act, you could perhaps almost go as far as to say bad facts make bad law, although that's a little perhaps arbitrary in the face of a unanimous Supreme Court decision. But if you look at the practical implications of the decision, it really shifts. It does take, I think, a rosy view of the very, very complex and prolific regulatory milieu in which most government contractors need to operate. If the regs were so clear, we wouldn't be in so much litigation. And the idea of using regulation to regulate is not, I think, a very sound practice to start with. So yes, I think what this does is it shifts the analysis from looking at what's a reasonable interpretation of the law to let's determine what the facts are here. So it becomes a much more facts-laden kind of investment of counsel's time and of the enforcer's time, as well as the relator's time. And because of that, it really cedes the interpretation of the regulations, which are difficult and complex, particularly if you're looking at the Medicare area or in national security area or in cybersecurity areas. Despite best efforts, a lot of times companies are struggling to ensure that they have a fair interpretation of the regulations. And the Department of Justice, likewise, is trying to determine a fair interpretation of regulations. And we've seen situations where the department has wanted to dismiss a case because there's enough ambiguity, for example, in certain Medicare or healthcare kinds of regulations that they can't quite come to an understanding of what is the unified government view of how these regulations should be enforced. And so they will dismiss that kind of False Claims Act. What this does, unfortunately, is shifts much of that to the relator. And so instead of the government determining what is the regulatory standard, the relator is doing that. And not only that, the relator is doing that through a much more extended discovery process, and a discovery process that obviously adds significant cost to the private companies that are under investigation. I might add that I think this also impacts how the Department of Justice will look at this, and maybe we can talk about consequences perhaps later. But from a very fundamental point of view, the Department of Justice obviously sees itself as the principal litigation arm of the United States government, and it is very concerned about having consistency in its precedential decisions that come from courts. And it usually takes care in what cases it brings and how it brings those so that it can define how the regulations are interpreted. What this does is it may have a two-pronged effect here. It may impact shifting the process to the relators, but it may also result in the government being a little more positive in exercising its power to dismiss these cases either because of the discovery burden or because of concerns about a problematic interpretation of the regulation. So yes, I think it's, it really has opened up an area that will be of significant concern to companies, those who are seeking government contractors who are seeking to provide goods and services to the United States government, as well as to perhaps the Department of Justice that is seeking to enforce to ensure that the interests of the United States are protected.
We'll definitely circle back to that sort of interesting interplay between the Polansky case and the SuperValu case a little bit later on, but thank you for raising that point, Jay. So Josh, at the outset of the opinion, Justice Thomas explained what the court's not reviewing, which included the question of whether the company submitted a false claim, but aren't the questions of knowledge and falsity somewhat more intertwined than he was sort of letting on?
Yeah, absolutely, Glenn. And just for context, the passage that you're referring to, in the passage you're referring to, the court says, we are not reviewing the meaning of the phrase usual and customary, or whether any of respondents' claims were in fact inaccurate or otherwise false, nor are we reviewing whether respondents actually thought the phrase usual and customary referred to their discounted prices. But you're absolutely right. Falsity and scienter are intertwined because the scienter inquiry is about whether you knew the falsity of the claims. And so I'd say two things about that connection. First, coming back to the point that I was alluding to above, the assumptions here about what the court was not reviewing make the case sound a lot simpler than it actually was. The discount programs here were in effect starting in 2006, and these cases were filed in 2011. But it wasn't until 2016 that a court of appeals decided the quote unquote correct meaning of usual and customary, and therefore that the claims submitted before that decision came down were false. The court's statements about what it was not reviewing don't engage at all with that disconnect. And the second point I'd make is that there's an interesting question going forward here about the interplay between alleged falsity and scienter. In this case, the alleged falsity and the claim for payment are very closely connected. The alleged falsity was right there in the reported price itself. But in other situations, as folks listening may well be aware, the alleged falsity is much more attenuated from the claim. I mean, there are cases, for example, where a relator will pick up on a FDA regulation about manufacturing requirements and then string that all the way to a Medicaid or Medicare reimbursement. And defendants may be able to argue in cases like that the relator should have a more difficult time on scienter in showing that defendants actually knew or considered the attenuated falsity, given how much these two elements are in fact connected.
So in terms of impact going forward, Steve, how do you think SuperValu is going to change or alter or impact how contractors defend FCA litigation, especially suits filed by relators?
Yeah, I mean, as Jay pointed out, and as I think the audience generally knows, there is, a lot of ambiguity out there in the regulations and other legal obligations. Contract documents are often contain ambiguous clauses. And I think in those instances, defendants, need to, or companies, I should say, need to establish, an objectively reasonable interpretation of the legal obligation at issue. I realize that sounds, like an oversimplification, but this is not always, the most economically advantageous interpretation. And, the government likes to say frequently that you have to turn square corners when dealing with the government. And that may be true, but I also think that, in certain instances, it may be necessary for companies to seek clarification from the relevant agency regarding, a particular interpretation of an ambiguous legal obligation, or the company's rationale for a particular interpretation of a legal obligation. And in the absence of clarification, I think continue to, follow the objectively reasonable, path, and continue to try to seek clarification if that's at all possible. And again, another comment I might make is that if it is possible to do this, avoid creating evidence. One of the issues in these two cases that came before the Supreme Court appeared to be the existence of some evidence that created an understanding that reflected an understanding within the defendants of competing interpretations that could be used by a qui tam claimant to support a False Claims Act case. That may be easier said than done, but if it is possible to do that by limiting internal discussion or documentation regarding, competing interpretations of ambiguous obligations, it certainly would help. And of course, at the time of trial, if a case is filed and it actually proceeds to trial, then the company will need to offer proof that its subjective interpretation during the relevant time period, during the time that claims were submitted, was consistent with its, objective interpretation, with the objectively reasonable interpretation of the regulation or statute. I know that, corporate law departments and compliance departments are responsible usually for interpreting these legal requirements. It's likely that one employee or agent, considering an ambiguous provision is going to construe it consistent with a reading that the government or a later qui tam relator favors. And so this is, going to be an ongoing problem. I suppose it's even conceivable that that person who came up with an alternative interpretation may end up being a relator in some subsequent False Claims Act case. And I think this is inevitably going to lead to increased costs for companies in defending these cases. That, there are also privilege implications that come into play here. And, these considerations involving corporate legal departments and compliance professionals likely involve legal advice, and in attempting to prove their subjective knowledge regarding a particular legal requirement, companies may actually be confronted with the prospect of having to waive privilege, which is extremely unfortunate.
Jay, in addition to some of the burdens on the government that this might impose that you had discussed earlier, is it likely that they're going to have more government contractors coming to them and asking for what's the right interpretation of this particular statute, especially in the Medicare context? There's so many regulations that could have so many different meanings. So I could see the OIG and HHS being bombarded with questions.
I think this case will have a fascinating impact on how the Justice Department addresses enforcement of the False Claims Act, particularly, and we'll talk about that later, perhaps, when you put it in conjunction with the Polansky decision. I mentioned earlier, the Justice Department does have a pretty historical ingrained view of the authority to try to drive interpretations of statutes, obviously in conjunction with the regulatory agencies that they represent in litigation. And as everyone else has both Steve and Josh have pointed out, we're going to have a lot more discovery here. So the government may have some ambiguous or maybe some bifurcated interest in how it proceeds, as it's gotten perhaps more authority under Polansky to dismiss cases at different stages. It may seek to exercise that authority to avoid prolonged litigation, ambiguous interpretation, or hostile interpretations of statutory schemes, et cetera. And it may actually take more control of the False Claims Act cases, which I would probably proffer for most defendants in the case is probably a preferred course. It has a potential to avoid extended litigation and more excessive costs. It's not always clear that the government has a significant concern about the costs involved. But I also think, this is going to, it's going to curtail summary judgment claims. It's going to curtail dismissals. It's going to drive a lot more engagement, I think, between the government and the putative defendants in these cases. And it may actually drive a lot more settlements in an effort to both interpret the regulatory schemes, but to avoid the extended discovery and to avoid just the whole process that can become 5, 6, 7 years once the government has ceded more control of the environment and the process to a relator. So it could have some positive perspective impacts from the government's perspective, and some of those could well spill over into the defendant's perspective, because in many ways it's in the interest of both of those parties to have a reasonable interpretation legally of what the regulations are. And yes, if you have a factual scenario where someone's reasonable interpretation isn't really supported by the facts, but in fact, it becomes an extreme kind of case, then that can be addressed and move forward. So I think there's an opportunity here for the Justice Department to exert more control, or more motivation to exert more control, and an opportunity for defendants to engage more with the Justice Department. And the Justice Department may be a bit more predisposed to have those discussions earlier on to avoid the prolonged litigation. But the flip side of that is they may wait and see how summary judgments and dismissal motions operate, and as a consequence, they might just lie back in the weeds and let things proceed to the disadvantage of almost everyone.
So Josh, you've spent quite a bit of time with this case as one of the counsels for the respondents. So if you have any final insights to share with our audience before we move on to Polansky, please go right ahead.
Sure, I'll just pick up on one thing that Stephen flagged, which obviously, as we've been saying, this decision leaves a lot of questions unanswered. The court decided it very narrowly. But one thing that I think looms large is the privilege implications. Respondents and a lot of amici pointed out what should be obvious, which is that where legal ambiguity is at issue, a scienter standard that focuses on a corporation's actual beliefs is going to put a lot of pressure on defendants to think about waiving privilege in order to show the full picture. In this particular case, a lot of the bad emails, quote unquote, ended with something like, let's loop in legal, redacted, so you can't show the whole picture if you don't waive the privilege. And that the court declined entirely to engage on that Hobson's choice. So part of the landscape going forward is going to be the reality that privilege is going to be placed under stress here, and hard judgments are going to have to be made in some cases about whether to waive, and if not, how to defend the privilege from relators and DOJ in order to show what a corporate defendant actually believed.
Thank you, Josh. So we'll move on to the Polansky case. So prior to the court agreeing to review the Third Circuit's decision in Polansky, there was a pretty pronounced circuit split that developed on the question of DOJ's ability to dismiss key tam actions, the amount of process due or later. Steve, you did a good amount of writing for us for our Legal Pulse blog on these cases as they sort of develop. So I thought you'd be a good person to address that split and the differing interpretations that came out of that.
Sure, of course. There have been several opinions, appellate court opinions, addressing the government's authority under Section C2A of the False Claims Act. So we call these C2A dismissals, and what standard should apply to a government's request for a dismissal under that provision. And the first case to take this issue up that is cited in all the other cases that discuss the history is United States ex rel Sequoia Orange versus Baird and East Packing Corp. It's a Ninth Circuit case that was decided in 1998. And in this case, the Ninth Circuit basically laid out a two-part test. The first part was identification of a valid government purpose. The government had to identify a valid purpose underlying its request for dismissal. It couldn't simply come into court and ask for a dismissal for no reason. And then it had to demonstrate in the second part of the test a rational relation between dismissal and the accomplishment of the valid government purpose. In this case, the government came in and actually made an argument that it frequently makes when it seeks to dismiss False Claims Act cases, and that is that the burden on the government from litigating the case or from having to respond to discovery in a case, just the drain on the government's resources or the agency's resources don't justify the continued litigation of the case by the relator. And so in Sequoia Orange, the case was dismissed, and that was affirmed by the Ninth Circuit. This was a fairly deferential standard. A few years later, 2003, the issue arose again in the DC Circuit, and the DC Circuit issued an opinion in the case of Swift versus United States and took a different approach. And in that case, the DC Circuit rejected this two-part Sequoia Orange test and actually held that the decision to dismiss a case like this is essentially akin to the exercise of prosecutorial discretion. And it's a matter that's not subject to judicial review for separation of powers reasons. And so the DC Circuit adopted an extremely deferential standard and would have granted the government's or affirmed dismissal of the government's grant of the government's motion dismissal of the case for just about any reason that the government might offer, or no reason at all. Another decision worth mentioning here is the Seventh Circuit's decision in a case that was decided recently in 2020. And in that case, it came out of the Southern District of Illinois, and procedurally is a little bit different because in the district court, the government's motion to dismiss the case was actually denied. And so there was an appellate jurisdictional issue that had to be a hurdle that had to be overcome by the government in that case, unlike Swift and unlike Sequoia Orange. And the Seventh Circuit ultimately decided that it could exercise jurisdiction, and it rejected essentially both Swift and Sequoia Orange and sort of came up with its own standard that is essentially grounded in Rule 41 of the Federal Rules of Civil Procedure, which provides the government with unfettered discretion to dismiss a complaint, a False Claims Act case, a complaint, before the defendant has answered or moved for summary judgment. And thereafter, if a hearing is required, any hearing on the propriety of the government's dismissal is exceptionally narrow, basically limited in essence to consideration of whether the motion involved fraud or the deprivation of the relator's constitutional rights. Those are basically what I would consider to be the three main approaches to a C2A dismissal motion by the government, leading up to the Polansky decision by the Third Circuit and eventually the Supreme Court's decision.
So Polansky followed the Seventh Circuit decision a little bit more closely than the others. That fair statement?
Yes, that's completely correct. Grounded in Rule 41 of the Federal Rules of Civil Procedure.
So in an 8-1 decision written by Justice Kagan, the court embraced the Third Circuit's approach over both the objections of the relator and the government. Josh, can you take us through the court's holding, both on what when the government can move to dismiss and what sort of processes do?
Sure. So the first piece of it is when the government can move to dismiss. And the court here held that the government can move to dismiss a False Claims Act action whenever it has intervened, whether that's during the seal period or later. So that didn't go quite as far as the government had asked, which was to say it can dismiss without even having moved to intervene. But it also didn't cut it off at the intervention decision, which is what relators had said. Their argument had been, once the government makes a decision to intervene or not, and decides no, then the case becomes the relators to proceed with, and the government can't come in later and dismiss. And the court said that the court ruled against that position, and while it didn't go quite as far as the government hoped, said they can move to dismiss at any point. And the second piece of it was what standard applies if the government does have this right to dismiss. And there, as Stephen has alluded to, the court held that the standard that applies to assessing a dismissal motion is the one that comes from Federal Rule of Civil Procedure 41A for voluntary dismissal. And that provision provides that the court can dismiss on terms that the court considers proper. Pretty opaque.
So the court was pretty clear in saying that while Rule 41 governs, the relator doesn't really have much of a chance of prevailing, right?
Yeah, exactly. So those terms are pretty opaque on their face, but the court did go on to say the government's view should almost always carry the day here. It said, for example, in most FCA cases, the standards will, quote, readily be satisfied. It said they'll be satisfied in all but the most exceptional cases, and the government's views are entitled to substantial deference. And in this particular case, the court said it was not a close call. And what the government had done in support of dismissal was enumerated significant costs of future discovery, including the possible disclosure of privileged documents, and explained in detail why the government had come to believe that the case had little chance of success on the merits, despite, of course, the relator's vigorous disagreement with that assessment.
So would it be fair to say that, as Steve noted from the Seventh Circuit decision, that it would have to be fraud or some constitutional deprivation? The court didn't sort of lay that out the same way the Seventh Circuit did, but you think those are the kind of factors that might be the unusual situation where a court will not allow the government to go ahead and dismiss?
Yeah, I mean, it sure sounds like it's going to have to take a lot going forward. Maybe it's fraud, maybe it's the government's position as articulated doesn't hold together, but it's going to be tough. I mean, saying discovery is going to be a pain, a thorn in our side. I mean, the government could probably say that in just about every case, right? And articulating why they don't think the relator's position has much of a chance of success probably just requires them to mimic some of what the defendants are saying. So it shouldn't be a tough bar.
So Jay, what factors should the government or will the government consider when weighing to intervene and obviously present to the judge in a Rule 41 hearing?
Glenn, I think the government has a wide panoply of interests when it's making this judgment, very different from when a relator is making a judgment about how to proceed with a case and what the process should be. The government's interest at foundational is, what is the public good here? And how does it protect the financial interests of the government? How does it prevent fraud against the government? And how does it manage the entire relationship? I will say the entire relationship, both the regulatory and the legal process relationship of the enforcement process. So you'll get, sure, what was the financial harm to the government? Is there some concern about the regulatory harm that's being fostered by a particular contractor's interpretation? And the flip side, I think, as Josh pointed out, I mean, there are issues of privilege, secrecy that really can implicate where the government wants to proceed and where it decides it may be more appropriate to dismiss an action, where the relator won't have those same issues. Recent cases where the discovery costs have gotten so large compared with what the outcome might yield in terms of financial benefits. And then it's, it has to look at what is the success opportunity on the merits. This isn't just throw something up against the wall and see what sticks. This is the Department of Justice, and presumably they are bringing cases where they believe they have a substantial probability of prevailing on the merits. And those standards are different from what a relator, even with a well-intentioned relator, will necessarily be grounded in, where it's primarily, what is the reward? What is the financial opportunity to me? As I continue to press this case, and since most of them are brought on a contingency basis, that's a very different kind of calculation that the government might weigh. Similarly, the government has alternatives that it can look to instead of just proceeding on the False Claims Act. I mean, it obviously has criminal prosecution. So if we have a government contractor who's behaving in a particular way that is really violative of what would be a common interpretation or a reasonable interpretation of some statute, and it's doing so in an egregious intentional way, the government may well either simultaneously or separately pursue a criminal matter, and that obviously is solely in the hands of the government. And secondly, they have debarment, or they have other contract actions they could bring against a contractor. And then I would say, which is something which I think folks probably don't necessarily think about, but there's reputation. I mean, most of the government contractors are not sort of one-off. I'm dealing with the government, so I'm going to exercise the most egregious interpretation of some action. The same is the flip side for the government. They're going to look at what's the reputation of this contractor, and knowing that this contractor is going to will have many other contract matters with the government simultaneously with the one that may be in dispute. So all of that comes to weigh in terms of how the government sees that particular contractor, as well as obviously it's weighing on how the contractor will respond and react to particular allegations made by the government. So at the end of the day, it's not just the financial impact, but the government may well decide, is this case worth the candle, to put it in a vernacular way? I mean, is it really worth us having to go through a very protracted process because we have a lot of confidential, secret data in black programs that we're going to have to deal with? Or is it worth the candle if we are going to get a distortion in how the rest of how the HHS or someone else is going to interpret the regulatory structure if it's forced to that position by a relator? So, it's a broad-based, one would hope, sound judgment-based judgment that the Department of Justice is making, and contractors, I presume, in most cases, rely on that sound judgment and in many ways prefer that sound judgment approach, as long as the government doesn't just sort of defer to the relator and say, hey, you do this, we don't feel we really have anything at stake here, and then they lose control of the case. And I think we'll talk about that a little bit more as we get into the Polansky and into Justice Thomas's view of this. But the government has a range of interests that it will determine whether or not to intervene. And as the Polansky case pointed out, I mean, they did not intervene, but they did subsequently intervene in order to dismiss this case because many of those interests outweighed the value of having the relator proceed with the case.
So what kind of role, Steve, can qui tam defendants and their lawyers play in bringing a lot of these concerns to the attention of those at the Justice Department, U.S. Attorney's offices, and others that are involved on the government side of false claims suits?
Is that directed at me, Glenn?
Oh, Steve, I'm sorry.
I'm happy to defer to you, Jay, but I'll take a crack at this. I mean, I think most of our listeners understand that when a company, receives word that there's a False Claims Act investigation underway, they're going to attempt to engage the Justice Department or the U.S. Attorney's Office in an effort to try to persuade the government that there's no there there. And if a qui tam case has been filed and there is the potential for the government to intervene, they're going to want to try to persuade the government not to intervene in the case. And in some instances, that may be outcome determinative. I think this dialogue may continue even after the Justice Department declines to intervene in a case in an effort to try to persuade the government to consider affirmatively moving to dismiss the case under C2A. And so some of these things Jay was alluding to, in general, and I've tried to have these conversations with the U.S. Attorney's offices, you need, I think, to try to impress upon the government the potentially significant downside to allowing a relator to continue to prosecute a case. And that can take a number of different forms. I mean, I think the most common is that there is going to be a significant burden, no small burden imposed on the government in terms of discovery or what have you. And that is a significant reason the government should consider intervening in the case and moving to dismiss the case. I might point out that most folks who are listening probably will remember that the Michael Granston wrote a memo and it came out, and it was thereafter known as the Granston memo, which laid out several different criteria under which the government might affirmatively move to dismiss a qui tam case. And those have now been codified in the Justice Manual that is a reference for U.S. Attorney's offices. It's section 4-4.111. And these, basically lay out a menu of circumstances under which the government might seek to intervene and dismiss a case. Burden is certainly mentioned, merit is mentioned, interference with agency policies, losing control of litigation. And one thing that I think is important that Jay has already mentioned, which is, I think, if there's a potential that a relator prosecuting a case could generate adverse publicity that is going to be a problem down the road for the government, that might be a good reason for the government to get involved in a case and try to get it dismissed before that ultimately happens. So those are some, examples of circumstances under which a defendant might engage the government in an effort to try to obtain a dismissal of a qui tam case.
Glenn, I just would add one thing to Steve's very insightful review there. I think you'll see an effort coming out of Polansky for defendants to really press the government to exercise its dismissal authority. And I think that's the undertow here in many ways to drive a settlement. You'll see instances where the government has elected not to intervene, but where it supports a settlement proposal, perhaps by a relator, but a settlement proposal that is really off the mark and doesn't really bear much relationship to the relative merits of the case. With Polansky giving a little more weight, I think, both from just the statutory interpretation, but more for the undertow of it's really adding power to the government under sort of Article 2 here, and we'll talk about that perhaps a little more. But for the government to exercise that, to maintain control of the False Claims Act process, and to drive reasonable settlements and to avoid unnecessary costs. Now, maybe these are just grand hopes of potential defendants, but I think in many ways, this provides a little more nexus and alliance between defendants and the government to deal with rather outlandish relator kinds of claims. And the government, one would hope, would exercise its authority respectfully there to not be so shy and sit on the sidelines and let the process really get off track, but to help drive a reasonable settlement of a matter.
Yeah.
So as interesting and important as all of this discussion has been, what's really causing a buzz in the defense bar, especially on the FCA side, is Justice Thomas's dissent and the two justices' concurrences saying that they agree with what Justice Thomas said, at least in terms of raising concerns. Jay, could you talk about the dissent a little bit?
Sure, Glenn, just a couple observations. I mean, if you look at SuperValu, Justice Thomas was, he took a very different statutory view, which, at least on the surface, you might think drives, I'll use this in terms of legal authority, legal power, drives more power into the hands of the relator, because it's basically saying, government, you better make your decision up front. You don't really have authority under the statutes to intervene later and try to control and manage the case, which is sort of, it's an odd view given what his dissent is with regard to Article 2 issues. But you might see it as sort of an interesting combination, because by taking his statutory view, he's saying the government actually has less authority, but Justice Thomas, thinks the government needs complete authority, or almost all complete authority, to manage this litigation. And since the way the statute is written, the government has less authority to dismiss, I think we need to look at the clear Article 2 kinds of issues that come into play here of executive power to manage and control litigation, particularly in, particularly in criminal litigation, but the False Claims Act is about as close to criminal litigation in many ways as you get in the civil litigatory area. And he speaks of clearly Article 2 authority, officers of the United States, and that private relators really they're not authorized to represent the United States. So you get some real tension there. And the real question is, and as you all know, I mean, Justice Kavanaugh and Justice Barrett sort of joined generally in a concurrence. They joined the majority decision, but they also gave a nod to Justice Thomas. They think this issue of Article 2 is worthy of a more insightful look by litigators and by the court. So this opens up a whole area, and it may be just scintillating to practitioners, because there have been other circumstances and situations where the Article 2 authority of the executive to control enforcement and litigation and decision making in enforcement in criminal areas has never quite gotten over the line as being exclusive. And the False Claims Act, of course, has a long history dating back to the Civil War and with the amendments in '86, et cetera. But the courts have been reluctant to push across that line. We saw a little of that in California recently with their Private Attorney General Act being upheld. So I think this is an interesting discussion for us, and it's a fascinating discussion for those who are engaging in current litigation. But there is a window here of opportunity where you have three members of the court suggesting that, maybe we've gone too far here in how some of the False Claims Act issues are interpreted and how it's structured. And that, the real remedy here would be for congressional action. And as I think all of us might well think, that opens up a huge can of worms. and a firestorm in many ways, because there's tremendous support in the Congress, or certainly in the Senate, for the False Claims Act, and there's a lot of engagement between former Senate staffers who are now in private practice and part of the qui tam bar in the Senate. So it would be a really fascinating set of legislative issues. But more importantly, I think it'll be interesting to see cases coming through. And I know Josh and Steve have far more insight into this than I do about how some of these cases coming along might well raise that issue, and whether it could be, might be, should be successful.
So in the interest of time, I'm going to jump into one of those cases, which is a case involving a device manufacturer, Exactech, which has filed a motion to dismiss a qui tam action, which alleges a reverse false claim theory, sort of classic expansion of the statute. So the motion picked up on Justice Thomas's musings on the False Claims Act and Article 2. Josh, tell us a little bit about that and what you think, how that might play out.
Yeah, sure. So the motion raises two Article 2 arguments. The first one under the Appointments Clause, and the second under the Take Care Clause. So the Appointments Clause argument is that only appointed officers can wield Article 2 power, and private relators aren't appointed at all. And the second, which is about the Take Care Clause, is that the executive branch has to maintain sufficient control over the case, the prosecution, in order to comply with the Take Care Clause, and the qui tam provisions go too far in the other direction by giving too much control to relators. What's interesting here, though, is that this is the inverse of the ordering that folks have typically pushed on these issues, and including what we did in our amicus brief for WLF and Polansky. And I think part of that is an offshoot of what Polansky actually held, because ironically, the response to the Take Care argument is helped a lot by Polansky's decision to keep the dismissal power alive and well. The argument that we raised in our amicus brief, and which in many respects is reflected in Justice Thomas's dissent, is that if you take away the government's power to dismiss these cases, you take away too much control over the prosecution and the ability to control the case. But Polansky leaves that dismissal power alive, and therefore it seems litigants have started to elevate the Appointments Clause issue as more absolute. The government has now filed a response to this brief, and perhaps unsurprisingly, given, among other things, the billions of dollars that come into the fisc every year from FCA cases, they defend the provision's constitutionality. On the Appointments Clause, the government leans heavily into the Stevens case from the Supreme Court, which held that relators have Article 3 standing based on their personal stake in the case, and the fact that the assignment of the government's interest is only partial. So the government says that relators are not officers or agents because they have a personal and private stake in the case. They also say that there's no practical indicia of an office of the United States in the position of a relator. An office of the United States is one that can be filled by different people over time. It's the same way the U.S. attorney for any particular district is filled by multiple different people. They say that's not what a relator is. Relators are one-off position, unique to any particular case, and therefore not an officer of the United States. And on the Take Care Clause argument, the government expectedly leans into the fact that it has maintained the right to dismiss, and it says there the inquiry is, does the statute prevent the executive from performing its duties? And they say that the qui tam provisions don't do that. Underpinning some of this, there seems to be some concern on the government's part about other statutes like Title VII and the Sherman Act, where private plaintiffs are allowed to enforce rights. And I think you see in some of the government's arguments a real fear about what a successful Article 2 challenge to the qui tam provisions might mean for other statutes. But that's the competing arguments now teed up in Alabama for decision.
So when we did our Supreme Court briefing yesterday, it was mentioned that in the government's brief in the Loper-Bright case, that the government argued that overturning Chevron would be a convulsive shock to the system. I would imagine that the same thing applies in the False Claims Act context as well. Steve, any final thoughts on the dissent or the Article 2 issue? You're as much in the trenches on FCA litigation as anybody here. So certainly your perspective is definitely, I think, interesting in this area.
Just, reading Justice Thomas's dissent, I'm coming away from it with the feeling that he feels quite strongly, even though he wants to kick this back to the Court of Appeals to consider the constitutional issues. I think he feels quite strongly that there is a constitutional infirmity here that cannot be overcome. And it was fascinating to me to see that Justice Kavanaugh and Justice Barrett seem to agree. I don't know if they feel as strongly about it, but they agree with him, I think. Ultimately, I just as a practical matter, because there is so much history behind this law, although he does address that issue. Historical viability is not a guarantee against finding that something is seen today as unconstitutional, but there is so much history behind this law and so many vested interests in not just in the False Claims Act, but in the key TAM provisions of the False Claims Act. It's really hard to see that the court would actually pull the trigger and find that the key TAM provisions of the law are unconstitutional. I'm going to continue to watch the litigation in Alabama, with interest to see what happens down there, and obviously whether this comes before the 11th Circuit will depend on what happens in the district court, whether that case is resolved on other grounds, whether it settles, or whether the constitutional issue becomes ripe for appeal. And it's just something that we need to continue to keep an eye on.
Jay, the sort of historical aspect of the False Claims Act and the argument that the government makes and relators have made in the constitutional context is a little bit weak in the sense that the law is much different after the 86 amendments than it was before the 86 amendments. Is that a fair sort of retort to those arguments?
I think it is. I mean, it has a long history, but 86 really set up a new statutory scheme, which really pushed a lot more authority, I think, to relators and obviously the incentives to relators. So, and the way it's developed over the last 40 years is such that I think that will weigh on the court, and I wouldn't be in a position to predict where this goes, but I agree with what Steve said, that Justice Thomas feels quite strongly about this. Justice Barrett and Kavanaugh obviously have concerns. It might well be that there's another one or two of the justices that would likewise have some general concerns about the Article 2 authority detractor here, and the take care, which is really pretty interesting. I mean, the take care argument, I think, is really quite interesting. So I will leave it there. I think this remains just a tremendously fascinating area of the law. It's obviously a significant statutory schema for the federal government to seek to maintain integrity in a huge component of our economy. So it could have a potential convulsive impact, as you said, with regard to the Chevron doctrine. But I think it will be pursued pretty aggressively by litigants.
Well, we were so clear and comprehensive in our discussion here that we don't have any questions from the audience. So we will leave it at that. Jay, Steve, Josh, thanks so much for joining us today. And thanks everyone who joined us online.
Thanks, Glenn.
Thank you.
Thanks, Glenn. Thanks, everyone.